Good afternoon. Welcome to the Environmental Law Institute. I'm Brett Cordy, the director of the Associates Program here at ELI, which is the department that brings you educational programs like our summer school series. You've joined us for the Basics of the Clean Air Act, which is an ELI public seminar and the fifth in our 2017 summer school series, which runs every Thursday in June and July. So there's two more left. If you haven't signed up for those yet, please do. We've got product regulation and hazardous waste and sites coming up still. For the audience in the room, first, big shout out for braving the 103-degree heat index that we're dealing with here in DC. For those of you sitting in your air-conditioned room behind your screens that didn't have to leave today, congrats. And for those of you in milder climes, enjoy it. If you're on the web, you can ask questions through GoTo's question box. There's a little chat function. You can send those to us. Please send them as soon as you think of them. That way we can either ask the panel at the appropriate time or I can kind of queue them up in a place that makes sense. And for those of you in the room, let us get you a microphone. I know everyone can hear each other in here, but that way the web can hear you as well. Either me or Sarah in the back will run you a mic. Video recording of today's discussion will be available within the next couple days. As with all of our summer school sessions, they are free and open to the public. You don't have to be an ELI member. But I would encourage you, particularly the students in the audience, to be an ELI member if you're not, because as a student, it's free. We've got full speaker bios on the website, and I've asked our speakers today to give a little bit of an overview of how they got to this seat right here. Which I've done for all of our speakers so far in this series. But I'll just give a brief introduction, just tell you who they are and where they're from. First, we have Aaron Ward, who is an associate at Hogan Lovells, and Hannah Graae, an associate at Hogan Lovells, and then Phil Assmus, who is with the National Association of Clean Air Agencies. Thank you all for being here. We really appreciate it. And with that, I'll hand it over to Phil, I guess, to give a little intro of yourself and how you got to the National Association of Clean Air Agencies.
Sure. Well, thanks. Can everyone hear me all right? Great. So my path to this chair is a bit zigzaggy. As an undergraduate, I studied physics. I actually spent some time in physics grad school, which was long enough for me to realize that I didn't want to do it anymore. So at that point, congratulations. I sort of made a calculated bet to move to DC and get involved in policy work. So I spent a few years on Capitol Hill. That was enough to convince me to go to law school. So I left, did that, came back to DC. Spent a couple of years practicing at a law firm, Hogan Lovells actually, where my two colleagues are from, and then decided I wanted to get back into the policy world. So I accepted a position with the National Association of Clean Air Agencies, where I am now. We are a nonprofit membership-based organization here in DC. We represent state and local clean air agencies. So like a lot of other associations, in Washington, but we're different in that rather than having members who are businesses or companies, our members are actually state and local governmental employees. And we do exclusively Clean Air Act work. The Clean Air Act, in addition to the federal standards setting piece, relies heavily on state and local air agencies to actually implement that. And we'll be hearing about that today throughout our panel. But we work very closely with those state and local agencies to weigh in with EPA as we can to help improve and affect various rulemakings and policy choices, but also we work quite hard to help state and local agencies understand, implement, and just work better with EPA and the rules that the federal agency issues. So I feel very lucky with what I do. Turns out I'm much more of a policy person than a practitioner. And I guess with that, I'll turn it over to Aaron and Hannah.
The practitioners. Hi, thanks, Phil. So I'm Erin Ward. I'm an associate at Hogan Lovells in our environmental group there. I also did not have a straight path to environmental law. I was an economics major in undergrad and took a brief little detour to econ grad school in agriculture and natural resource economics. So it actually dovetailed nicely, but I had no idea that that would happen down the road when I did it. I did a couple years of economic litigation consulting, which has come in oddly handy. Environmental law actually ends up having a lot of economic analysis, a lot of cost benefit, a lot of data. So that's been great. I went back to law school to UVA. I was actually focused a little more on health law, which is also dovetailed reasonably nicely into environmental law because of our focus on public health. But then I came to Hogan after clerking for a year with a Fourth Circuit judge and joined our environmental practice. My practice is primarily Clean Air Act, although our group doesn't necessarily only do that, but it's been a big focus because this is, there's just a lot of work in this area. There are a lot of sub-programs that are all huge in their own right, as you'll hear a bit about today. So I do a lot of risk management programs, a lot of stationary source work, and fuels compliance, gasoline, diesel, renewable fuels. So it's been really fascinating, and I've loved getting to learn about it. But it definitely was not a plan from the beginning, but I love where I ended up.
I'm Hannah Graae. I'm also an associate at Hogan Lovells in the environmental group. I guess maybe my path was a little bit more of a straight line. I did wildlife ecology and conservation biology as my undergrad majors. So I always knew I had wanted to do something environmental related. And then after college, I was a paralegal at a law firm for 2 years, and then went to law school at Duke, and also did I did a master's at the same time in environmental studies, and then ended up at Hogan. And again, I had kind of known that I wanted to do environmental the whole time. I wasn't quite sure if I would go sort of to a nonprofit or a law firm, or even to the government, but I really liked Hogan's practice, and like Erin said, it's actually, I also do pretty much exclusively Clean Air Act. In fact, I currently pretty much only do mobile source stuff, which is what I'm going to be talking about today. But I've been with Hogan for 4 years, and certainly while I've been at Hogan, I've done a lot of other areas as well, including hazardous waste, like some TSCA and FIFRA stuff, definitely Clean Water Act, Endangered Species Act. So, you know, the practice sort of runs the gamut, but certainly these days it seems like Clean Air Act is really probably the biggest focus, I would say, for our work. So yeah, and I'm very happy to be here today. So.
All right. So I'm going to start out. First, we're going to give you a general overview of the Clean Air Act. This is going to be very high level. There's a lot of details here that we're omitting today. I encourage you to investigate anything that strikes your fancy as we go, but we're going to try to keep it pretty high level. And then I'll focus a little bit on some parts of Title I, which is the stationary source portion of the Clean Air Act. And I'll hand it over to Hannah for some mobile source, and then over here for some climate change and what's left of that. So let's going. So I'm going to talk about the basic structure, a little about the history, and some of the federal statutory requirements. So the Clean Air Act that we have today has gone through a number of transformations. It all began because we were seeing a lot of the similar air issues that we see in China and some other developing countries today, a lot of smog, cities being very crowded. There are a lot of incidents related to people having significant health impacts from poor air quality. So originally there was the Air Pollution Control Act of 1955 that was focused a lot more on research and just trying to figure out what the health effects were and what kind of things they could do. And then as concerns about air hazards increased, there was particularly a incident in London where there was an inversion that trapped the smog in the city for a few days and 4,000 people died. So that raised the profile of this issue pretty considerably. And then the Clean Air Act, the original one, was passed in 1963. And then there have been a few amendments to that, including the Air Quality Act of 1967 and the Clean Air Act amendments in 1990. And of 1970. So in 1970, they charged EPA with establishing National Ambient Air Quality Standards, which we call NAQS, and directed EPA to help the states, this is a state-administered program, as Phil was mentioning earlier, so to help the states meet these standards. So EPA had to set a certain level for a number of different criteria pollutants that we'll go through in a moment. And then the states had to figure out how to meet those levels through an implementation program. And they've come up with a number of strategies of how to make that happen. So the basic structure of the Clean Air Act, Title I is air planning, prevention of significant deterioration, non-attainment, new source performance standards, air toxics, and enforcements. Title II, which Hannah will be discussing, is mobile sources. And then Titles 3 through 6 are a little smaller, except that Title 5 is actually how we implement Title I, which is a fun twist in the Clean Air Act. But yeah, Title 3, general provisions, definitions and such. Title 4, noise pollution. Then we have acid rain. Operating permits are the permits that control how we attain all of the requirements in Title I. So I won't be talking about it directly, but that's the implementation program there. And then we have an ozone provision. So within Title I, there are a lot of sections, including a lot of the work that I do. So there's air quality planning. Prevention of significant deterioration will be areas that are doing well with respect to criteria pollutants. Non-attainment is areas that are not doing so well. And almost I think every part of the country has some pollutant that they are non-attainment for at the moment. New source performance standards, when you have so when we say source, we mean a source of air pollutants. So mobile sources are cars, trucks, buses, things that move and produce air pollution. Stationary sources are ones that stay put. And they are sources of air pollutants, so like factories, refineries, chemical plants, that sort of thing. And then air toxics, anything you put in the air that's hazardous, and of course, enforcement of all of these provisions. So the new source performance standards are under Title I. Basically, EPA set emissions standards for new types of sources, so like a smelter. If you're going to build a new source of that type, so new source, they set a certain emissions limit for how much you can put into the air. So you have to implement controls to limit the emissions that you are putting into the atmosphere. And this has particularly become important in the context of greenhouse gases most recently, which Phil will discuss a bit more later. Briefly, mobile sources, though Hannah will go into much more detail. So this includes cars, trucks, buses, as I mentioned. And then recently, greenhouse gases from airplanes. I don't know if that's still a thing. That was an Obama thing. So essentially, it's all about cars and trucks. You've heard probably a lot about Volkswagen recently. We'll discuss that a little later. But any sort of emissions controls on cars to prevent the kind of smog that comes from those. So here again are the other provisions. And we won't go into a lot of detail about these, but it's good to know kind of where we are. So let's see, Title III, definitions, enforcement provisions. Title 4A was part of the 1990 amendments and established a cap and trade system for the regulation of sulfuric oxides and nitrous oxides from power plants. This has been a pretty successful program, which is great. Title V came about in 1990 mostly because there was a lot of confusion about how to implement all the Title I requirements and how to keep track of all of the different emissions limits. And so they put them all into a permit, and you have to apply for that permit to the state and get it approved. And so that way the state can control how they're meeting all of their different requirements under Title I. And then Title VI is an outgrowth of the Montreal Protocol and is aimed at regulating ozone depleting substances. So not ground level ozone, but a little higher, stratospheric ozone protection. And this has been a very successful program, a little more so perhaps than the one trying to control ground level ozone. So we're going to dive a little bit into some of the stationary source work. This is a huge program, so we're really only covering some bits and pieces, but hopefully we'll get you the high level information. So National Ambient Air Quality Standards, or NAAQS, as I mentioned before. So the Clean Air Act requires EPA to set these, and the goal is to figure out how much of these air pollutants can be emitted into the air and still have it be safe to breathe. And over time, they've lowered those minimums as companies have achieved the levels and states have achieved the levels that they have set. So basically, to set these standards, EPA takes a cubic meter of air and asks how much of each criteria pollutant is safe to breathe in this cubic meter of air and still be healthy. One important piece to note is that costs cannot be considered by EPA when setting the NAAQS. And so if they decide that a certain amount that's the most that's safe, then it doesn't matter how much it will cost us to achieve that level. That's where they set it. They can also consider uncertain science. They don't have to know exactly what is harmful to human health, but can set it based on reasonable assumptions. And then they can also allow for a reasonable margin of safety. So, not everyone reacts the same way to pollutants in the air. Children, the elderly, people with asthma will react differently, and they can take that into consideration when they're setting these standards. All right, so we're going to walk through what these criteria pollutants are. So criteria pollutants are the ones under the statute that EPA has to set limits for. So particulate matter is the first of 5. So there are 2 different sizes of particulate matter that EPA measures. There's particulate matter 10 and particulate matter 2.5, and that's millimeters? Yeah, millimeters across. So particulate matter 10 will be bigger pieces of soot and smog, and then 2.5 is smaller, easier to get through things, but they have slightly different harms to your lungs and your body. So these result from incomplete combustion of carbon fuels, basically. So like when you're burning a wood fire at a campground, you'll see, soot and smoke and things emitting. If you ever stood in front of the campfire and the wind changes, you'll know that becomes a little harder to breathe. So that's what we're concerned about on a grander scale, are these big particulate matters in the air. They can come out of things like diesel engines from trucks and buses. It can also come out of coal-fired power plants, which has been a source of concern over the past decade or 2. So essentially, it's any time that you're trying to burn something and it doesn't burn completely cleanly, and you end up with little bits of these carbon matters that end up emitted into the air. In terms of health effects, they can cause lung damage when you breathe it in, causing cardiovascular and respiratory problems. Large particulate matter you may be able to get rid of by coughing, sneezing, swallowing, but fine particulate matter is a little more dangerous because it can really get stuck in your lungs and hard to get out. And then there are other chemicals you can absorb through those particles, like mercury, that get on the little dust bits, and then you breathe those in and they get stuck in your lungs. So really not good stuff, not what you want. In terms of environmental effects, they can lead to the visible haze that you see in cities like Beijing around the world, and it impairs visibility. So on the left here, we see 15 micrograms per cubic meter. On the right, we see 45 micrograms per cubic meter. So that's a pretty dramatic change. It looks like fog essentially on the right. So this is the impact of particulate matter. It's bigger, so it's more visible and create visibility issues as well as all the health impacts. The next criteria pollutant is carbon monoxide. So this is also caused by inefficient combustion of carbon fuels. In a vehicle engine, you burn gas at lower temperatures, and instead of converting all the carbon to CO2 and water vapor and emitting that, some of the carbons don't fully oxidize and end up as carbon monoxide, which many of you may have carbon monoxide meters in your houses, so you know it's pretty dangerous. So about 80% of these emissions come from motor vehicles, like Hannah will be talking about later. In terms of health effects, it's pretty deadly. So it tricks your blood cells, and they go into your lungs with the goal of picking up oxygen, but instead they pick up carbon monoxide, thinking it's O2. And And once they pick that up, they can't get rid of it. So your body doesn't get the oxygen it needs, and then your blood cells are poisoned. So if you breathe too much of it, you can die. And if you breathe a little of it, you can get really bad headaches, start feeling very sleepy. So not good. In terms of environmental effects, anything that has any sort of blood, hemoglobin, can be impacted. So it's primarily an issue with anything with lungs, including us. All right, so then nitrogen dioxide, or nitrous oxides you'll sometimes hear, and ozone. These are combined because they're related. So nitrous oxide is actually from high temperature, highly efficient combustion of carbon fuels. You also get this out of diesel engines and gasoline. We've been able to develop a lot of tools to limit this in mobile sources. But the problem is, as we have more efficient combustion, we reduce the carbon monoxide and increase emissions of nitrous oxide. So we have other ways like catalytic converters to try to control these emissions. And vehicles are about 60% of these emissions in the U.S., and then fuel combustion from stationary sources is most of the rest. In terms of health effects, ozone is very reactive. It can oxidize your lung tissue. That's not good. So it can cause lung damage, cardiovascular and respiratory problems. So pretty significant. You may get ozone alerts occasionally on your weather apps to warn people who have sensitive lungs to stay indoors. I don't know if there's an ozone warning with the heat index today, but there may well be. It also has a significant impact on the environment. It can oxidize crops the same way it oxidizes in your lungs and disrupts photosynthesis. And then there are also a lot of concerns with the greenhouse effect, which Phil will be discussing a little later. Also, nitrous oxides are very unstable. In the presence of heat, they can turn into O3, ozone. So nitrous oxides are paired with ozone because they can actually be transformed into ozone molecules. And that's where we get the greenhouse gas issues. So we try to reduce nitrous oxides both for their direct impact on health, but also for their potential to become ozone molecules and have additional impacts that way. So you may see warnings to take public transportation or try to walk on days when nitrous oxides are high, and that's with the goal of reducing the amount of ozone that might be created by those high nitrous oxide levels. So next we have sulfur dioxide. So these are a little different. The primary source of this is coal, but it's also in crude, diesel, and gasoline. There are some regulations in the Title I area for fuels to reduce the amount of sulfur in gasoline. We have much lower levels in this country than they have in Europe because we've been trying to control that. Fuels combustion is 85% of SO2 emissions in the U.S., so it's primarily from burning fuels. In terms of health effects, it can turn into a fine particulate matter like we were talking about earlier and cause lung damage. It used to be that we were mostly concerned about the environmental impacts, but now we've realized that there are actually a lot of health effects as well in terms of lung health and breathing capacity. Also, environmental effects. It combines with water vapor to form sulfuric acid, which is not something you want to mess around with, and it comes down as acid rain. It increases the acidity of water bodies, which can have pretty devastating effects on the environment like we see here. And it can also cause haze like we were talking about earlier with the particulate matter. So this lack of visibility here is created primarily from sulfur dioxide emissions, and you just don't want to be breathing that. And then there's lead, which you probably all are a little familiar with. It's the first and only pollutant to be added through the petition process as a result of successful litigation by the NRDC. Lead primarily came from lead in gasoline. We thought adding lead to gas was a great idea once upon a time. We've since changed our mind on that one. So they moved to unleaded gasoline a pretty long time ago at this point. It was used to smooth out the combustion process once upon a time. They've since come up with other ways to do that that are a little less poisonous. MBTE replaced it, and then they figured out that that had some other issues. So this has been a continual problem of what to put in our fuels that helps them run better but also doesn't kill us separately. In terms of health effects, lead will kill you. It's not good. There's a lot of concerns about lead in paints as well that you've probably heard about. So that's pretty nasty. But we've come a long way in getting that out of our fuels and out of our systems. So as I mentioned earlier, in terms of the standards, they set standards for each of these. And then each region, they have specific regions that they will assess that are smaller than state level. And they are determined by EPA to either be in attainment, which means they're meeting the standard, they're at or below it, or non-attainment, so they are higher than it. I think the DC area is non-attainment for ozone at the very least. I'm not sure which others. And they were supposed to be met nationwide by 1975. That was a little optimistic. So they gave EPA 5 years in 1970 with the amendments to get all parts of the country into attainment with these standards. It's become more of a iterative work in progress. EPA does keep lowering the numbers, so they've sort of set a moving target as technologies improve and we're able to control it, and as research improves and they learn more about some of the negative effects from smaller amounts of these. So EPA keeps lowering the standards. Regions keep trying to comply. Most areas have non-compliance for something. So every part of the country is in non-attainment for something, I believe. But most of them are in attainment for most pollutants at this point. There are some areas like LA, which have a lot of trouble with some of these because of all the cars and air pollution there. EPA is required to review these every 5 years to make sure that the NAC is still adequate and still protecting health. They don't always get around to those on time, but they do keep resetting them. I think there was one in 2008, and maybe, I think one more since then. So they do primary and secondary as well. Primary NACs are designed to protect human health, and secondary NACs are to protect the public welfare or the environment. So they're setting some different standards based on what research they're looking at. But because EPA has interpreted human health pretty broadly, in practice there's not that much of a difference between primary and secondary. And in the context of ozone, it's become particularly important because there are studies that suggest that the ozone NACs are not strict enough to protect the environment in particular. So environmental groups have been lobbying a lot to try to get those lowered. So this is what the full list of NACs looks like right now. I'm not going to walk through all of these, but for your reference, and this is available on EPA's website as a good reference tool. So how do we achieve these NACs? So you achieve them by air quality planning. So Section 107 of the Clean Air Act divides the country up into these air quality control regions, which are the regions I was just mentioning, or AQCRs. I don't know if there's a fun way to pronounce that one. Not aware of it. Hackers. No, AQCRs. So it's not about whether the whole country is in attainment. It's region by region, and they evaluate those regions every so often. And they evaluate them for each criteria pollutant, as I've been mentioning. So like we can be in attainment for carbon monoxide, but not in attainment for ozone. They generally follow pre-existing state and county boundaries, so they're not usually forming their own little sections. There are some areas like the DC area, which combines DC and a couple of the surrounding counties on either side. But usually it's within a particular state, so they have more control over regulating that area. And so each state develops a state implementation program, or a SIP. to figure out how they're going to achieve these standards. So that's the cooperative federalism principle, where the states and the federal government are working together to figure out how to achieve these. So EPA has ultimate oversight responsibility, but they hand off a lot of the administration and figuring out how to achieve these to the states. And EPA will approve those SIPs, and then the states run with it. Why we took this approach is, these are really often local issues. They're, local sources, specific, how much urban area you have, where those urban centers are. So this is the sort of thing that's much easier to figure out how to implement at a local level, even though, EPA is setting these national standards in general, but how to achieve those is going to depend a lot on your local circumstances. So this, dual approach was seen as the best way to try to achieve these standards at the national level. There we go. So states will submit their SIPs to EPA for approval. If it meets the requirements, EPA approves it. If not, they can either approve it in part, they can reject it, and create a federal implementation program. I think everywhere either has a SIP or some joint thing at this point. There may be one SIP somewhere, but I think it's mostly SIPs at this point. In theory, EPA has a year to approve it, but that doesn't always pan out. In terms of how to achieve it, these are some of the tools that they use. I'm not going to run through this in the interest of time, but they have a lot of tools in their toolbox on how to approach achieving these goals. And then if you fail to either submit an approval SIP or implement one, EPA, or you can have your federal highway funds restricted. EPA may create a FIP and take over control of implementing the program. They can refuse to approve construction permits. There are a number of enforcement tools that EPA has at its disposal to make sure that states implement these effectively. So within an attainment area, if you are in attainment for a particular criteria pollutant, there are different ways that we approach trying to keep those emissions under control, and these are handled through that permitting process under Title V that I mentioned earlier. So PSC, Prevention of Significant Deterioration, is the permitting and standards that are applied to attainment areas. So any new sources or major modifications in an attainment area will have to deal with the PSD part of the permitting program. And this is essentially geared towards trying to prevent new sources from taking that area out of attainment into non-attainment. So it's a way to limit and control new sources of emissions as they're built. It requires the use of best available control technology, which allows for the consideration of available technology and cost. And it requires air quality monitoring and modeling. So to assess best available control technology, or BACT, the new source will have to identify all available control technologies that fall within how the source is intended to be created. So if you want to build a power plant, you don't have to build a water facility instead in order to meet the BACT requirements. So you start with your basic design and then look at all the control technologies available to limit emissions or otherwise control emissions before they get into the air. From there, and there's a clearinghouse that lists the technologies available, so you don't have to go do that research yourself. You can eliminate anything that's technically infeasible for what you're doing or just not feasible yet in the market. So carbon capture is an example of that. And then you rank those control technologies, evaluate what's most effective, considering economic and environmental considerations, and then you figure out what your best available control technology is. So that's going to be very case-by-case dependent. In terms of non-attainment, there's a whole separate permitting section and program and requirements for that. And then depending on how bad you're doing in terms of attaining, you'll have different requirements on how you have to reduce emissions. So this is just an overview of air quality planning. All right, so before I get there, so basically there are different requirements depending if you're in attainment or non-attainment, all geared towards bringing non-attainment areas into attainment. So those are going to have more strict control technologies imposed on them. You're going to have more limits on what you can build and how much they can emit. Or if you're in attainment, we want to keep it that way. So two different parts of the permitting program, but any new source, new modification to an existing source is going to have to take these into consideration, apply for a permit, and get it approved before they can start construction. So that's how EPA has approached keeping these under control. So next I'm going to talk about a part one that's been in the news a bit lately, the Renewable Fuel Standard. If you've heard about Carl Icahn and some ethical investigations into him, that's all related to the Renewable Fuel Standard. So this was established by the Energy Policy Act of 2005 and amended in 2007. And the goal, there were several stated goals, but primarily it's focused on increasing the use of renewable fuels in the transportation system specifically in the U.S. and reducing our dependence on foreign fuels. So there's a security component and building up the domestic renewable fuels industry and trying to reduce the amount of carbon fuels, non-renewable fuels that are in use in transportation each year. So there's annual volumes that are set by the statute for the amount of renewable fuel that is supposed to be blended into non-renewable fuels to be used in transportation. So if you go to the gas station, you may see a little sign that says contains 10% ethanol. That's renewable fuel that's been blended into your gasoline. And then there are four nested categories. So these are based on how effectively the renewable fuel reduces greenhouse gas emissions. So renewable fuel is a catch-all. All renewable fuels fall in there. Ethanol is a renewable fuel. Advanced biofuel reduces it by, I believe it's at least 50%. And there are some specific fuels that EPA has identified as falling within that category. And then biomass-based diesel is using biomaterials to make essentially a diesel fuel that can be blended into diesel. In some cases, it can be used on its own. And then cellulosic biofuel was the great hope of the future that is not quite panned out at this point. They're still working on that, but it's using, so cellulosic materials, it's like the substance of the plant. So not the sugars from it, but the actual like stalks and materials to try to make a biofuel. So biomass-based diesel and cellulosic biofuel are both nested within advanced biofuels. So those fall under those categories. And then all of those count as renewable fuels. So EPA, with the assistance of the Energy Information Administration, estimates the fuel consumption, so the fuel demand for each coming year. They're in the process right now of doing this for 2018. They've just released the 2018 numbers like a week ago. Actually, I think we're still waiting on it to be published, but they released what they're planning to do. So they estimate what the fuel consumption will be and then what percentage of renewable fuel the fuel market can accommodate. The goal is to reach those statutory levels. We've had trouble doing that in the advanced and cellulosic categories, so they have a waiver authority based on inadequate supply, environmental concerns, economic concerns that they can use to reduce those levels from the statutory volumes that were set by Congress. In the last several years, they have used that authority to lower those amounts that must be met by producers. They're currently in litigation in the DC Circuit over the 2014 to 2016 renewable volume obligations, which is what they call the amounts that they have to blend. So refiners and importers are obligated parties, which means that they are required to meet these renewable volume obligations. So they're the ones responsible for making sure that a certain amount of renewable fuel is blended into these non-renewable fuels. That's been a source of a lot of the news lately is certain parts of the industry are trying to change who the obligated parties are and when you become obligated in the supply chain, because there have been some problems of a little bit of misalignment of certain companies are obligated but don't have the ability or market power to blend. Other companies are blending but aren't obligated. So there's been some frustration with some of those companies about what their obligations are. So that's been in the news a lot recently. You may have seen that. And then RIN, which you also may have heard about, are used to track compliance essentially. It's the tool that they use to measure how much renewable fuel has been blended into non-renewable fuel. So refiners and importers who are obligated parties have to obtain a certain amount of RINs either by blending fuels themselves or by buying them from other parties who did the blending, and then they have to send those DPI to prove that they complied with the rule. And this is all a lot, I know, so feel free to ask me questions later. I know we're running a little behind on time. So this, you'll see the slides later, and it just sort of shows you the process from producer or importer all the way through service station and when the fuels get blended. So when they're blended, you separate out the RIN and then you can use it for compliance. So until it's blended, you can't take credit for renewable fuels. So trying to get those blended fuels into the marketplace. So there have been a lot of issues that have arisen with this particular program, and it's the focus of both EPA and Congress this year to try to figure out ways to improve it. There have been a lot of cases of RIN fraud, a lot of volatility in the price, particularly as we've hit some walls in terms of our production levels and our ability to blend. Ethanol can only be blended to 10% right now at certain times of year or for certain vehicles, so that's limited the extent to which we can blend, which then limits some companies' ability to meet those obligations. You also can't blend more than, I think, 2% of biodiesel into diesel in the winter, because otherwise that affects the engine function. We've relied a lot on foreign imports for certain types of renewable fuels, particularly biodiesel. So our interest in not relying on foreign fuels has been a little compromised because we've changed from relying on foreign non-renewable fuels to relying on foreign renewable fuels. So not quite achieving the goals of the statute there. There's also an investigation right now into biodiesel dumping, which is sending a good to a foreign country at a lower price than it costs you or lower than market price, and sort of flooding the market with low-priced goods, which can impact the domestic price. Usually it's a result of significant subsidies in the source country. So like Argentina and Indonesia have a lot of local subsidies that have been helping biodiesel, and then they've been sending it here at lower prices. So there's currently an investigation by the Department of Commerce and International Trade Commission to determine whether they are dumping, in fact, and whether a duty should be imposed on those imports. Also, as I mentioned, disputes over who should be obligated, where along the supply chain that should fall, and then advanced biofuels have really failed to develop the way Congress hoped when they first promulgated this statute, and so that's created a lot of shortages that have caused problems for parties trying to meet their obligations. So these are all very hot topics right now that Congress and EPA are working hard to consider how to make this program work better and achieve the goals that Congress originally had laid out. Okay. Are there any immediate questions on that? I know that was a lot of material to try to cover in a short time, so I'm happy to answer questions now or after. Yeah.
Is ethanol also not
Oh,
better?
wait, hold on.
Yeah, Mike, sorry. There we go. Okay.
Is ethanol also not better carbon emissions-wise?
There's definitely a lot of dispute about that, whether the environmental benefits are really what they were supposed to be. Ethanol in particular is not great. The other advanced biofuels were intended to be better, and the original vision was that ethanol would kind of kickstart the renewable fuels industry, and then it would transition over time to more advanced biofuels that have significantly fewer greenhouse gases. Actually, a lot of ethanol and such was grandfathered in, so it doesn't even have to demonstrate a 20% reduction, which is what renewable fuels are supposed to achieve. So there have been a lot of concerns from environmental groups about the actual environmental benefits or lack thereof from ethanol, in addition to considerations of growing more corn to produce it and all the impacts. So that's been a subject of debate for sure, and they didn't envision ethanol being the sole source of renewable fuels. But the way just technology is developed and the way like a lot of these are very heavy products, like cellulosic matter has a lot of water in it, and so you can't transport it that far, so you need a lot of little plants kind of everywhere. And so getting that infrastructure in place and getting that to develop, getting funding for them has been a problem. So yeah, there are concerns about that. All right.
Okay,
Anna.
so we're going to sort of pivot now to talk about Title II of the Clean Air Act, which focuses on mobile sources. The reason why we're sort of addressing this today is because there's really been an increasing interest from EPA on this industry sector. Obviously, EPA is going to continue to remain interested in stationary sources, but we're definitely seeing more interest, as I'm sure you've heard of the Volkswagen scandal, and what's now developed into Dieselgate that's involved a lot of other car companies as well, which we're going to talk about that in a little bit more detail. So Title II of the Clean Air Act is divided into three parts. Part A is the motor vehicle emission and fuel standards. Part B is aircraft emission standards, and then Part C is clean fuel vehicles. We're really only going to focus on Part A today because that in and of itself is a lot going on. So that's going to be our focus today. So what is a mobile source? It's basically anything that has an engine and is not a stationary source. So the things that you would typically think of are the car or truck that you might drive personally. Of course, it also includes heavy-duty trucks and buses, motorcycles, but it's also much more broad, as you see on these non-road categories. It even includes your lawnmower, an aircraft, locomotives. So it's a very broad category. And with respect to the criteria pollutants that Erin had gone over, they're really sort of all in play here. They're all regulated for mobile sources, but really the main ones of concern are NOx and also greenhouse gases, CO2, PM. So that's sort of the main concerning pollutants here. This graphic is sort of putting the mobile source emissions in perspective with respect to greenhouse gas emissions. So you can see the transportation sector is responsible for about a quarter of the greenhouse gas emissions in the U.S. And then when you break that down a little bit further, you can actually see that the light-duty vehicles, the cars that you and I drive, actually make up the vast majority of that within the transportation sector. So that's really why EPA is focused on this industry. It makes up a large portion of what the emissions are in the U.S. So now sort of diving into the Title II provisions, it's really about two things. First, it's making sure that vehicles are compliant with the emission standards at the time that they're put into commerce. So that means at the time the car is manufactured and sold. And then it's also about making sure that that car stays compliant throughout its useful life. The Title II provisions, there's different emissions limits and standards depending on the vehicle category that you're in. So, you know, there's separate standards for light-duty vehicles, heavy-duty, marine engines. So you obviously got to pay attention to what category you're in. But generally, the process for certification is somewhat similar across the board. And at a baseline, all vehicles and engines have to be covered by a certificate of conformity in order to be sold in the United States. And they also must meet the full useful life requirements that are in Title II. And the full useful life we've put that up here. So for light duty, it's about 10 years or 120,000 miles. Heavy duty, it's also 10 years, but you see it's a lot, the mileage is a lot more. It's about 435,000 miles for heavy duty. So from a compliance perspective, sort of looking at the life cycle, the OEM, the original equipment manufacturer, that's how we refer to basically the car companies that make the cars. They put together the certification application, and that's where they're going to demonstrate that the engine or the vehicle meets the emission standards for that category. They have to perform testing, both the durability testing that I was talking about and also evaporative emissions tests. And they also have to have a statement of compliance. So that's kind of the certification bucket. And EPA reviews that and then would issue the certificate of conformity. There's also OBD or onboard diagnostic system requirements that are pretty onerous. Those are mainly in California's court, so the California Air Resources Board, or CARB. They're really in the driver's seat for OBD. It's kind of their thing. For context, the OBD system is basically, it's a really sophisticated computer system in your car. So anytime you see like a warning light or a malfunction indicator light nil in your car, that's your OBD system working. It's basically designed to make sure that the components in your vehicle are working as they should. And that includes the exhaust after treatment system of your car. So that's the part or the system in your car that treats the emissions that your car puts out and basically prevents you from just dumping, raw NOx into the atmosphere, which Erin talked about a little bit earlier. There's also production conformity requirements. So these are really designed to make sure that what's coming off the manufacturer's production line actually matches up with what the OEM has certified. And then there's in-use compliance requirements. I think probably the most interesting in that category are the PEMS equipment, Portable Emissions Monitoring System, or PEMS system. It's a relatively new development that's really changed the landscape for emissions compliance and enforcement. Basically, historically, when you want to measure the emissions of a vehicle, you have to put it on what's called a dynamometer or a dyno, which you can basically think of that as like a ginormous treadmill for a car. So the car is not going anywhere, but the wheels are turning, but it's not going anywhere. So it's literally like a treadmill. And it's performed in a lab. The testing is performed in a lab in a dynamometer. With the invention of PEMS, it's actually a piece of equipment that can be hooked up to a car, and then the car can be driven on the road, and it can measure the emissions of the vehicle while you're driving it on the road. So it's really changed the way that EPA and CARB have looked at emissions. It's brought a extreme focus on what's called real-world emissions. And we're going to get into that in detail when we talk about Dieselgate and what happened with Volkswagen, because that was really key there. So I think the PEMS is probably the most interesting thing there. And then also emissions defects and recalls. If a manufacturer reaches a certain threshold of defective vehicles, they have to do recalls. So this, I'm not going to go into a lot of detail on this because I think I've already kind of explained it, but this kind of shows you the life cycle of a light-duty vehicle, starting out with the certification application, which is reviewed by EPA, and then they issue the certificate of conformity, and then the sort of black part of the timeline is for the useful life requirements of the vehicle. And so again, I'm not going to focus on that now, but okay, now we get to the juicy stuff. So I will warn you, there's a lot of information and detail on these slides, and I'm not going to go into every bit of detail, but I think you guys have access to these slides. So feel free to go back and read up on all the details. And of course, you can ask me if you have any specific questions. But to give you sort of the lay of the land from a legal perspective, there's a couple of parts of the Clean Air Act that are really important for this case or these cases. As I mentioned before, probably the biggest requirement with the Title II provisions are you have to have a certificate of conformity in order to sell your vehicle in the United States. You cannot sell a vehicle without it. And you cannot get a certificate of conformity and then sell a vehicle that doesn't meet what you certified to. So that's going to be one of the keys going forward here. Oops, did I miss one? No, okay. Another provision is the anti-tampering provision. So the Clean Air Act prohibits all persons, literally anyone, this includes an OEM or a supplier, from removing or rendering inoperative any part of the vehicle that was designed to comply with emission standards. So that's the tampering provision. Defeat devices. Again, all persons are prohibited from selling or installing any part or component that is designed to bypass, defeat, or render inoperative any device or element of design in the vehicle that is supposed to comply with emission standards. So any part of your exhaust after treatment system, basically, and other components as well. So those are the main legal provisions that you're going to want to have to keep in mind as we talk about this. So how did Dieselgate start? And I'm sure probably most of you have read about the Volkswagen case. Basically in May of 2014, some researchers at West Virginia University, I think they were also partnered up with a, I think it was a nonprofit organization. They started, I think initially what they had planned to do was try to prove to the EU market that their diesel vehicles could actually be better, because the US diesel vehicles had much better certification numbers, and so their mission was to say, look, you guys, you can do better. So they started testing these VW cars using the PEMS equipment that I told you about before, driving them on the road. And they discovered really high emission levels that were much higher than what they were supposed to be certified to. And in fact, it was basically 11 million vehicles worldwide, going all the way back to model year 2009, that were affected by this issue, approximately 600,000 in the US. So we are talking about a pretty big population of vehicles here. So of course, people started asking questions. What's happening here? Why are these, quote, real world emissions so much higher than what VW had certified the cars to? Well, basically what happened was VW had installed software on their diesel vehicles that enabled the vehicles to detect when they were being tested on a dynamometer. So they were able to tell when the agency was conducting an emissions test. Now, remember I told you the dynamometer is like a treadmill, right? So it's the car's on this thing, the wheels are moving, but it's not going anywhere, and the wheel is not, the steering wheel is not turning. So they were able to use certain inputs, using the computer system to detect certain inputs to tell that the vehicle was being tested on a dynamometer. And while the vehicle was on the dyno, all of the emissions control technology worked perfectly. It was great. It was just like they said it would be. But then the minute the vehicle detected, oh, we're not on a dyno anymore, it would reduce or shut off those after treatment systems. And in effect, what happened was these cars were driving around on the road emitting way, way higher pollutant levels than they were supposed to. So I think the 2.0 liter diesel vehicles had NOx emissions up to 40 times higher than the EPA legal limit. So that's that's what happened with VW. Oh, there we go. Okay, so EPA had obviously a bunch of issues with this, and this is where it sort of touches back to those legal provisions that I highlighted earlier. These are the claims against VW, so selling vehicles that were not covered by a certificate of conformity, installing defeat devices on these vehicles, tampering with emissions control systems, and also there are provisions in the Clean Air Act for reporting Clean Air Act violations as well that were violated here. And then in addition to that, there are criminal liability here and also civil suits from customers, from shareholders. There's a securities lawsuit. So VW is and was having claims from all angles, pretty much. This is a really high-level overview of where VW ended up. VW agreed to spend a total of $25 billion, that's billion with a B, in the U.S. To address claims from owners, environmental regulators, U.S. states, and dealers, and also to make the buyback offers to their customers. VW also pled guilty to criminal charges brought by the DOJ, and at least six VW executives so far have been indicted. So this is no joke. This is the biggest settlement in all of EPA history. And as I'm going to talk more about, it continues. That was not the end. I'm not going to spend a lot of time on this slide because the other slide is a better sort of summary, but if you want more details about all the specifics that VW had to do, this is an interesting slide to look at. But I won't spend a lot of time because I know we're a little short. So in addition to all of that, VW is still not out of the water. They still are facing claims from individuals who opted out of the class action lawsuits. There's ongoing securities actions and also state lawsuits against VW for violations of state environmental laws. So they are still not out of the water. And in addition to that, we're seeing an expanding scope of this Dieselgate scandal. Other OEMs and even potentially suppliers are starting to be in the crosshairs here. I don't know if you've been following the news. You may have seen some reports about Audi recently. So certain Audi diesel vehicles were covered under the VW settlement agreements or consent agreements, but that apparently was not all of the naughtiness at Audi, and so EPA is now discovering additional functions or functionalities in additional Audi vehicles that they are going after Audi for. So Audi is absolutely in the crosshairs right now. There's civil and criminal investigations ongoing. In fact, just last week, an ex-Audi engineer was arrested in Munich, and the U.S. DOJ issued a criminal indictment. So there's with 3 potential charges against him. And those charges apparently, according to the press, are based on an internal whistleblower at Audi. So again, that's heating up and something to watch in the news. You'll probably see more press about that in the coming weeks. FCA, Fiat Chrysler, also NOVs, notice of violations, have been issued both by EPA and CARB for violations of the Clean Air Act with respect to undisclosed AECDs, auxiliary emission control devices. Those are relating back to basically devices that can impact the way your exhaust after treatment system works. And you're supposed to disclose those in your certification application materials so that the agency, is transparent, the agency knows about it, and either can say, no, we don't like that, or, okay, we understand why you need that, we approve it. There's also been a civil complaint filed against FCA by the DOJ on behalf of EPA just this past May. And there's criminal investigations ongoing. And in addition, a lot of class actions, including class actions that have named at least 2 of the FCA suppliers, Cummins and Bosch. And then from a supplier perspective, we don't really know where that's going. It's a little bit more of a sort of attenuated liability under the Clean Air Act, because of course the suppliers aren't the ones that are making and certifying these vehicles. But I think probably the most talked about example would be Bosch. You've probably seen them in the headlines because they are facing a number of class actions in connection with the VW and Audi scandals. But we have not seen to date any criminal or civil claims against Bosch, at least in the US. And it's believed to be because Bosch has apparently cooperated fully with the authorities. And so apparently their cooperation has paid off well for them so far. But we don't know what will happen next. It's probably likely that other investigations will heat up, and other OEMs and even other suppliers may end up in the crosshairs. So we also saw recently, just I think on Monday, the new EPA administrator talking about these mobile source cases, in particular talking about VW and Fiat. And indicating that he thinks they should be dealt with very aggressively. So we can assume that even with this new administration, this will remain an enforcement priority going forward. So definitely something to keep watching. These last 3 slides, I'll kind of just glide through them, but they're really designed to show you the changing landscape of mobile source regulations globally. The U.S. is absolutely the leader in this area. But as you'll see from these changing graphics, the rest of the world is catching up on this. And so this is going to be an issue of global interest going forward. So that's it. I think I probably spoke way too fast. It gets me really excited. If you have questions, feel free to ask. Otherwise, we can move on to climate change. Yeah, wait for the mic. There we go.
Okay, thanks. Okay, why did Volkswagen do that? What did they gain?
So that's a great question. Basically, the main reason for doing it is because you get drivability and fuel economy benefits. So from a drivability perspective, a lot of these emission control systems, they basically, the way we've heard it described a lot is they kind of make the car clunkier, so it doesn't drive as smoothly, it doesn't feel as nice to a driver. And then in addition to that, without these controls, you save gas. So your customers, the vehicle owners, are going to have to go fill up their gas tanks a lot less often, and that makes people happy.
So the controls are mostly aimed at the pollutants in the gas,
Yes.
but they're not a carbon emission.
Correct. The controls are mainly designed to reduce NOx emissions. And so as a result of that, you sort of have these other impacts on the vehicle, but when you remove the controls for NOx and some of these other criteria pollutants, you can have better fuel economy as a result. Yeah, so it's a really good question, because you do kind of wonder, like, why would you take that risk? But yeah, I mean, that's basically why.
Thank you.
Yeah, absolutely. Good question. Cool.
Thank you. All right, good afternoon, everyone. For the 3rd and final chapter of this session, I'm going to be talking about the regulation of greenhouse gases under the Clean Air Act. I've already talked about the National Association of Clean Air Agencies where I work, so I will just jump into what exactly I'm going to cover. I will start with a little bit of basic background on greenhouse gases and greenhouse gas emissions in the U.S. And then from there, I'm going to take a largely chronological approach to the various ways in which climate pollutants and greenhouse gases have been regulated under the Clean Air Act, starting with 2007 to 2012, which coincides roughly with the last years of the Bush administration and President Obama's first term. Then I'll move into 2013 through 2016, which again largely correlates with President Obama's second term. And then finally, I will conclude with some updates based on what the Trump administration has been up to since it came into power. This is a very fresh and relatively fresh and still very dynamic regulatory landscape. It started about 10 years ago with some litigation that made it all the way to the Supreme Court, and it's still very active today. This is a set of issues that you're going to continue to read about on many different fronts in the news, both with respect to the issues that I'm going to talk about, and then other climate change related areas that maybe don't fall as explicitly under the Clean Air Act, but are still nonetheless important. A good example of that being the Paris Agreement. So first, some background on greenhouse gases. In short, they are gases that when emitted into the atmosphere, they absorb infrared radiation and can trap heat, raising the average temperature of the global atmosphere. Though CO2 is the most prevalent greenhouse gas, it's the one we talk about the most, there are others, and not all are created equal. Sort of on a pound-to-pound or molecule-to-molecule basis, some of these pollutants have stronger global warming effects than others. There's a system called the global warming potential that has been developed to capture those differences. It's expressed in terms of the amount of warming you'd expect from the same amount of carbon dioxide in the atmosphere. So as you can see, carbon dioxide, when emitted, has a global warming potential of 1. It sets the units. And then the other examples are actually all more potent. So methane has a global warming potential 25 times stronger. Nitrous oxide is 298 times stronger. Erin mentioned this when she was going through some of the criteria pollutants and how that I haven't included them in this table, but again, if I had, you'd see as you go down the table that they have higher potentials. And then I also highlighted HFCs, of which there are many different flavors, which can range from 124 times the warming power of CO2 to 14,800 times the warming potential. So even though you see vast differences in global warming potential, it's still the case that CO2 is it's the most important greenhouse gas to pay attention to, primarily because it's really solely due to its predominance. It is the thing that we emit the most of. And then in addition to some of these other ones that are listed, once CO2 is in the atmosphere, it stays there for quite a long time. When we try to do inventories of these things, the global warming potential idea is crucial. And so this slide gives us a snapshot of the most recent inventory of greenhouse gas emissions from EPA. They found in a report released earlier this year that total U.S. emissions in 2015 were 6,587 million metric tons of CO2 equivalent. By CO2 equivalent, it means that they basically tallied up all of the emissions from all the different types of greenhouse gas pollutants that they track, and then they express them in common units. So for example, for every metric ton of methane that EPA measured in its inventory, that translates to 25 metric tons of CO2 equivalent in the total inventory. Looking at trends, the 2015 number represents a 3.5% increase from the levels measured in 1990, but a 2.3% decrease from the previous year, and an 11.5% decrease from 2005. So there's actually been a fairly sustained downward trend in total U.S. greenhouse gas emissions over many years. Peak emissions in the inventory occurred in 2007, just over 7,000 million metric tons of CO2 equivalent. corresponding to a 15.5% increase over 1990 levels. This is a breakdown of that 2015 inventory in a couple of different ways. Hannah showed us one of these pie charts already, but I think it's instructive to revisit it again. On the left, we have total U.S. greenhouse gas emissions by economic sector, and on the right, we have total U.S. greenhouse gas emissions by type. I mention these again because they are essentially roadmaps to the regulations that we've seen EPA roll out over the last 10 years, and then again the regulations that the Trump administration has started to take steps to roll back in its first months in office. On the left, you see that by sector, electricity and transportation lead the pack in terms of total emissions. And on the right, the two biggest pie slices are for methane and carbon dioxide. And so again, as we walk through my presentation, the regulations that I'm going to spend the most time talking about all deal with the electricity and transportation sectors and then CO2 and methane emissions. So we'll start by talking about Massachusetts versus EPA. It was a Supreme Court case decided in 2007, and this is really the formal beginning of the story of regulation of greenhouse gases under the Clean Air Act. The case started with a 1999 petition where a group sent EPA a letter asking the agency to regulate greenhouse gas emissions from mobile sources, and in particular asked the agency to make a finding as required by Title II of the Clean Air Act that the emission of greenhouse gases from mobile sources endanger public health and the environment. EPA in the later years of the Bush administration refused to regulate greenhouse gas emissions. They were promptly taken to court by a group of the original petitioners and a number of other NGOs and states, including Massachusetts, which gives the case its name. By the time it made it to the Supreme Court, there were two issues on the table. The first relates to standing, which is a legal doctrine that is important but not terribly relevant for today's discussion. And then secondly, and much more relevant, to actually examine EPA's decision not to decide the question or to not do a formal endangerment finding process related to greenhouse gas emissions from cars. On that second issue, the Supreme Court struck down EPA's decision. They found that greenhouse gases are air pollutants within the meaning of the Clean Air Act, which isn't itself enough to guarantee that they'd be regulated. You have to have an air pollutant, and then you have to determine whether or not that air pollutant actually meets the endangerment criteria. And so on that second issue, the court basically said, EPA, you've got to take a look at the question. You've got to think about it in a way that's constrained by the statute and not avoid the question as you sort of attempted to do in the past. So in 2009, in the first Obama term, EPA approached the question and they made their endangerment finding. First, they found that the emission of 6 anthropogenic greenhouse gases endanger public health and welfare by causing climate change. And I've listed them all here. These should look familiar. A number of them appeared in the table that I presented earlier with global warming potentials. So in addition to the causal connection between the emission of these climate pollutants and climate change, they further found that combined emissions of these substances from automobiles causes climate change and then can contribute to a number of negative impacts that, as the endangerment requirement in the Clean Air Act requires, endanger human health and welfare. Once they had the endangerment finding, the agency moved on to mobile source standards. Hannah did a great job giving a nice detailed overview of that program, so I won't spend too much time here, but I will quickly note the passenger vehicle standards are rolled out in 2 phases, the first in 2010, the second in 2012. And they're essentially fuel efficiency standards. The first phase applies to model vehicles or model years 2012 through 2016, so we've actually completed those standards. It imposes increasing fuel efficiency requirements that started at 30.1 miles per gallon in 2012 and increased to 35.5 miles per gallon in 2016. Phase 2, promulgated in 2012, begins with model year 2017, runs to model year 2025, will increase fuel efficiency all the way to 54.5 miles per gallon by 2025 if it remains intact. Embedded in the regulation is a requirement that EPA conduct a midterm evaluation to basically examine, to take a look at how the program is going and to ask whether the future fuel efficiency standards remain practical, and then decide to either keep them or, if necessary, revise them somehow. And I want you to put a pin in that detail because we're going to be revisiting that later when we talk about what the Trump administration has been doing. So once the mobile source standards were completed, there were a lot of sort of necessary impacts that trickled through the Clean Air Act. And to get at that, I have to raise the concept of cross-triggering. We've heard a lot about the various, Aaron and Hannah have both talked about the various different ways that EPA treats mobile sources and stationary sources differently. The statute is very complex, it's big, it has many different pockets of programs. Some of these programs are more siloed off from each other than others, but as I said, some of them interact. So in some cases, regulation of a pollutant under one program can necessarily trigger or potentially trigger regulations of that same pollutant from different sources in other programs. And that's exactly what happened with the mobile source standards. They raised issues with two other EPA programs, the PSD and Title V programs, both of which Aaron mentioned. The PSD program applies to stationary sources and non-attainment areas with the potential to emit 250 tons per year of any air pollutant. That's in the statute. The Title V program applies to stationary sources with the potential to emit 100 tons per year of any air pollutant. Two programs and then two basic questions that the mobile source standards raised. The first is a question of when. We're talking about any air pollutants with the regulation of CO2 from mobile sources. It would seem that CO2 then becomes an air pollutant. So the question was when that might be the case and when EPA might have to start regulating sources under the PSD and Title V programs. To answer the when question, EPA issued the timing rule in 2010, which said, sort of made a legal determination that greenhouse gases became air pollutants subject to regulation when the mobile source standards went into effect, and thus became any air pollutant for purposes of the PSD and Title V programs. So that's the cross-triggering move where mobile source standards led to regulations under stationary source programs. The second issue was thornier, and that I'll walk through the slide to try to explain. It was basically a question of scope. Greenhouse gases are emitted at much higher amounts on a per ton level than your traditional criteria pollutants. So if you just stick with the 250 and 100 ton per year thresholds that are written in the statute, you have some huge practical problems. So Title V, which covered 15,000 sources prior to the mobile source standard, was predicted to expand to a total of 6 million qualifying stationary sources if you stick with the statutory thresholds. Similar problem for the PSD program. That one would have ballooned from 300 to 40,000. This was a huge practical problem, and so to solve it, EPA issued something called the tailoring rule, which instead of going with the statutory thresholds of 100 and 250, proposed regulatory thresholds of 75,000 tons per year, which were much more practical for the amounts of CO2 that were emitted, to try to kind of pare down the program, and then sort of promised to revisit that threshold in future years and lower it as was practically possible and as the program was implemented. Of course, all of this was challenged immediately. The lawsuit started in the DC Circuit. It included everything. It included the endangerment finding, it included the mobile source rules, it included the timing rule, and it included the tailoring rule. EPA essentially ran the table in the DC Circuit. They won on everything. So of course this was appealed immediately, and the Supreme Court only agreed to hear the case on a couple of limited issues. So it let It left the DC Circuit's ruling upholding the endangerment finding stand. It left the mobile source rules in place. But it looked very, very closely at the tailoring and the timing rules. And the verdict was one that was at best a mixed verdict for the agency. The Supreme Court rejected EPA's attempt to set a regulatory threshold that was different from the statutory thresholds, and in practice said that EPA was forbidden from regulating stationary sources under the PSD and Title V programs based solely on their emissions of greenhouse gases. However, the agency was allowed to retain jurisdiction over stationary sources that are anyway sources. So they are sources that would be covered under the PSD or Title V programs anyway because of their emission of other pollutants. And if that were the case, they could then be subject to the PSD and Title V requirements for greenhouse gases, which practically speaking means backed, which even more practically speaking doesn't mean a whole lot, but they're in. In terms of numbers, it meant that about 83% of the sources that EPA thought would be covered by the tailoring rule were still in the program. So they didn't actually lose that much from a certain perspective, but from another perspective, this was a fairly significant rejection of EPA's attempt to interpret regulations, and stepping sort of out even within a climate context, even stepping more broadly to an administrative law context. This case is one of a few recent cases that have sort of come to stand for key limitations on EPA's authority to interpret and implement its statutes. The third and final case that's relevant in a climate context in the Clean Air Act is called AEP versus Connecticut. Of the three, this is a little bit less significant. It's here mostly for bookkeeping purposes. It's a very interesting case, but again, not terribly consequential as of yet. A group of several states filed common law nuisance claims against 5 large power companies to force these companies to limit their carbon dioxide emissions. When this eventually made it to the Supreme Court, the court decided that the petitioners were prohibited from bringing federal common law claims because the Clean Air Act itself represented a clear congressional decision to remove the common law cause of action and instead replace it with discretion from EPA to regulate climate pollutants. So there aren't a huge number of practical implications that have stemmed from this decision, but importantly, it does reaffirm the reasoning in Massachusetts versus EPA that CO2 and other greenhouse gases can be included in the Clean Air Act, and to affirm that if EPA decides to exercise authority to regulate greenhouse gases under the Clean Air Act, that authority is there. That concludes the first wave in my chronology. The set of stuff that happened in response to litigation that played out over the later years of the Bush administration, and then President Obama's attempts to sort of deal with that and then implement some climate regulations in his first term. Towards the beginning of his second term, he started to take a more aggressive and comprehensive approach. In June 2013, the president released something called his Climate Action Plan, which was an executive agency directive designed to help meet a broader U.S. pledge to reduce greenhouse gas emissions to 17% below 2005 levels by 2020. The action plan relied on a mix of agency and executive authorities. So I'm going to be talking about the EPA Clean Air Act pieces, but there was a lot of other stuff included in the Climate Action Plan as well. The Clean Air Act specific pieces, so again, this is in addition to the mobile source standards that I talked about, so we're moving from one slice of the pie chart to other slices, involve reducing CO2 emissions from the power sector, an even larger source than transportation emissions, at least back then. Also taking steps to reduce methane emissions, which is the second most significant climate pollutant. And then other steps, expanding the mobile source standards to include heavy-duty vehicles as well as light-duty passenger vehicles. And then also separate steps to reduce HFC emissions, which again appear in the pie charts that I showed earlier, but are a smaller slice. The tool that EPA leaned pretty heavily on to accomplish this is found in Section 111 of the Clean Air Act. I want you to sort of think about how this fits with some of the other programs that Aaron and Hannah talked about. The Clean Air Act distinguishes between mobile sources and stationary sources. It targets specific pollutants. Section 111 is in some ways a hybrid of that. To use the section, you have to pick both a type of source, and in this case, it's all stationary sources, and then pair that with a pollutant. And once you do that, you can use, pursuant to Section 111B, you can regulate emissions from those sources, from new sources, modified and reconstructed sources. And then once you've done that, you can move on to use Section 111D to get same pollutant from the same sources but existing sources. There are some significant and important differences between both of these sections, aside from the fact that one applies to new and one applies to existing sources. Section 111B is a little bit more prescriptive. In both cases, EPA has to go through an exercise to determine the appropriate level of emissions controls. The insider practitioner acronym for the Clean Air Act in this case is BSER, Best System of Emission Reductions. For 111B, it actually will prescribe an emission standards that these sources have to meet in states. For 111D, the agency instead prescribes a set of guidelines that tell states a little bit more generally what they have to do to construct a plan to meet the emissions goals. 111B has been used quite frequently. It applies to more than 70 different types of source categories. 111D has been used much more rarely. Prior to the Obama administration, it had been used only 6 times on its own. The first big set of rules to come out of the Obama sort of second term deal with power plants. So this slide is summarizes the 111B standard for new, modified, and reconstructed power plants. It was finalized on October 23rd, 2015. And I've spelled it out here. I don't need to walk through exactly how the rule applied to all the types of source categories that it captured. The most important column is the leftmost column that tells you what the standard did for new coal-fired plants and new natural gas-fired plants, in particular coal-fired plants. For coal, EPA determined that a technology called carbon capture and sequestration was BSER for coal-fired plants, and then required that any new coal-fired power plant that is constructed come equipped with that system. And the end result was a predicted emissions intensity of 1,400 pounds of CO2 per megawatt hour. For natural gas-fired units, they did a totally separate BSER analysis, and rather than imposing a particular technology, simply said you need to build these plants to basically like your best specifications to best practices, and that would get you an emissions level of 1,000 pounds of CO2 per megawatt hour. On the same day that EPA finalized the new source performance standard, they finalized another rule called Clean Power Plan, which is the one that has been the most reported on. And this is and was the centerpiece of President Obama's climate agenda. It's the rule that has the most significance. It's a rule that has the highest cost. It's also the rule that has the most significant carbon reduction benefits. This is the 111D rule that pairs with the new source performance standard on the previous slide. So this gets you to existing power plants, which again is the biggest slice of the pie on the emissions inventory graphic I showed earlier. The rule was quite complex. It was prescriptive in some ways, but also included a lot of flexibility. Generally speaking, states were required to submit compliance plans, reducing CO2 emissions from their combined inventory of coal and natural gas-fired power plants. But they had a lot of flexibility, both in terms of the target that they chose. and then also the way that they got there. The targets themselves were based on a BSER analysis where EPA looked at trends across the power sector, tried to predict where technology, where emissions were going, and found that states could reduce their emissions through a combination of heat rate or efficiency improvements at the power plants themselves, but also through generation shifting from affected coal-fired units to natural gas-fired units, which basically means generating a higher percentage of our total energy from gas-fired rather than coal-fired power plants, which works because natural gas has about half the CO2 emissions of carbon dioxide in a power plant setting. And then the other factor that EPA considered is new zero and low emitting generation, so additional generation from wind and solar, zero emissions there. So to the extent that you have natural gas and renewables offsetting and taking over market share that was previously occupied by coal, you get pretty dramatic decreases in emissions. And EPA projected that more or less over the lifetime of the rule, when fully implemented, you'd get a 32% decrease in power sector emissions compared to 2005 levels by 2030. Very significantly, this rule was stayed by the Supreme Court on February 9th, 2016. So it didn't exist in the wild for that long. The stay happened months before any of the initial plan submittal deadlines hit. And so while this rule is incredibly significant, no state has had to comply with it. The rule has been stayed. Litigation is ongoing, and I want you to put a pin in that as well, because we'll loop back when we talk about what the Trump administration has been doing. The next significant rule I want to highlight from the Obama years are methane limits for oil and natural gas sector sources. These both, again, fall under Section 111. The first, the new source performance standards, were finalized on June 3rd, 2016. They include leak detection and repair requirements for oil and natural gas activities and equipment. And when EPA did the math on emissions benefits, they calculated that the rule would achieve annual reductions of about 11 million metric tons of CO2 equivalent. After completing the new source performance standards, much like they did in the power plant context, EPA began an effort but did not complete regulation of existing oil and natural gas sector sources. And they really only got as far as something called an information request, which is a survey out to the industry, the potentially covered parties, so that the agency could better understand the emissions profiles and the emissions control technologies that they were dealing with to set the standard at the appropriate level. Then the election happened, and everything changed. So as much as climate policy, climate regulation under the Clean Air Act has evolved and changed dramatically from Massachusetts versus EPA to the end of the Obama administration, we've seen another dramatic shift from January when President Trump was sworn in. That was perhaps most sharply evident on March of this year when President Trump released his executive order to promote energy independence and economic growth, which if you remember the climate action plan in Obama's second term, you can sort of think of this as a response to that. The executive order sets out a number of substantive priorities for the agency, much in the same way that the climate action plan set out climate mitigation priorities. And then the memo also, or the executive order also includes a process for agencies to follow. And so it basically operates on three tracks. It immediately revokes certain Obama administration policies. For those that it could not revoke immediately, it initiates a review process to conduct more time-intensive, more resource-intensive rulemakings to either suspend, rescind, or revise certain policies. And then it also established a more general framework for agencies to review their full sweep of policies and to then again ask the question, is this policy consistent with the goals of the executive order? And if it's not, let's consider a process to suspend, rescind, or revise those policies as well. By the numbers, the order took direct aim at a bunch of different stuff, more or less falling into one of three buckets. It targets specifically 5 EPA actions. It targets 5 actions and policies at the Department of the Interior, and then also 13 White House executive orders. Among the White House executive orders targeted by the executive order are specifically President Obama's Climate Action Plan, which is no longer operative. As an executive order versus executive order, the newer one wins. Those are very easy for subsequent administrations to revise or eliminate as they see fit. Rules are much more complicated, and we'll get into that in a little bit. Of the 5 EPA rules that were targeted specifically in the EO, 3 are related to the Clean Power Plan. 1 targeted the new source performance standards for power plants, and then the 5th and final targeted the oil and natural gas sector new source performance standard. Before I get into those, I want to briefly talk about how the Trump administration has viewed the mobile source standards. As I said earlier, that phase 2 of that regulation that goes all the way out to model year 2025 includes a midterm evaluation. One of the final actions of the Obama administration was to actually sign a final midterm review that preserved all of the existing mobile source standards up to 2025. So it meant that they attempted to lock in that ultimate goal of achieving more than 50 miles per gallon in model year 2025 cars. One of the first things the Trump administration did was to announce that it would be revisiting that decision. So you had the final Gina McCarthy signed EPA order on January 12th, and then on March 15th you had basically a counter notice signed by the new administrator, Scott Pruitt, announcing that the agency would revisit the decision. The deadline in the regulations is April 1st, 2018. So that's as much time as the current administration has to complete a process to change or undo the determination that the Obama administration made. And so if they want to, if they find that there's a need to lower the stringency of the mobile source standards, that's their deadline to do it. I haven't seen much in the trade press and activity there yet. So other than the announcement itself, it's unclear exactly how far along the administration is. There's been much more action on the power plant rules. I'll start with the new source performance standards. So the 111B rule for power plants that relies on carbon capture and storage. That rule remains in effect. It is expressly under review pursuant to the executive order. And in light of that review and in light of stated intentions from the Trump administration and legal filings, DC Circuit litigation that was filed to challenge the rule is essentially on hold while EPA reconsiders its position. Again, this rule is still on the books, but there are strong signals that the agency will take additional regulatory steps in the coming months and years to take it off the books. A little bit more action on the Clean Power Plan. As I said before, the rule remains stayed under the Supreme Court order, so it is not in effect. The DC Circuit litigation challenging the rule actually got as far as an oral argument. And many, especially in the environmental community, I think anticipated a victory and had hoped that the court would render a verdict before the Trump administration took power, and then even after that. And in short, it didn't happen. At this point, the Trump administration has asked the DC Circuit to halt proceedings, to refrain from issuing a decision, and the court has more or less granted that wish, and that litigation is on hold as well. In the meantime, this is probably the rule at the leading edge of the process called for under the executive order that Trump issued. The Federal Register has seen a notice of review for the rule, And in fact, we know that a draft rule to presumably suspend, revise, or rescind the Clean Power Plan has already been submitted for to the Office of Management and Budget for review, which is sort of an internal step before it actually gets released to the public and gets published in the Federal Register where we can all see it. So there is a draft. We just don't quite know what it says yet, although we have some guesses. For oil and for the oil and gas sector methane rules, this has sort of been the other area of focus for the Trump administration in terms of quick action. The new source performance standards rule is really interesting. In fact, stuff may have changed while we've been sitting here. In addition to sort of playing the longer game to rewrite the rule later, Administrator Pruitt earlier this year issued, in fact, shortly after the rule went into effect, issued a 90-day stay to pause implementation of the rule, which again is under review pursuant to Trump's executive order. A number of environmental groups very quickly challenged the 60-day or the 90-day stay, and just a couple weeks ago, the D.C. Circuit struck down EPA's action and actually put the rule back into effect. So that decision was subsequently appealed. Briefing was completed yesterday, and so the D.C. Circuit could come down with another decision related to the immediate effectiveness of the new source performance standard rule any day now. Aside from that, there is a separate process again to both review the rule and to impose a 2-year stay. So though the D.C. Circuit decision is a significant example of the courts holding the administration to a particular process, the practical impacts are probably going to be limited to the short term because the agency has a lot of discretion, and given enough time, it's again indicated an intent to pursue a slower moving rulemaking to eliminate the rule. For the existing source performance standards, the Trump administration had a much easier time to roll them back. As I said, they weren't anywhere near completion. They were in a very preliminary stage. And so to end them, all the administration really needs to do was to withdraw the information request. So that went away as soon as the notice was published in the Federal Register. And as long as the agency doesn't take steps to develop them, we probably won't see them anytime soon. So where does this leave us? I thought I would sort of wrap up with a slide containing an analysis from the Rhodium Group that in May released some modeling results to project where U.S. greenhouse gas emissions might go under a set of Trump administration policies. And so you can see the dashed vertical line separates the historical data from projected data. You'll notice going back, you can sort of see the highest point on the graph. That's the 2007 emissions peak that I talked about earlier. But you see the steady downward trajectory. And even though I've just run through a long list of climate regulations that have emerged under the Clean Air Act, most of this has happened without regulation. And most of this has happened because of market-based shifts in the power sector. And all of those factors that EPA called out in its analysis for studying the Clean Power Plant standards, shifts away from coal towards natural gas, increased renewables generation, have been the big drivers of these reductions. And so the real question is, well, what do we expect to see moving forward? And Rhodium is essentially projecting a flat set of U.S. emissions, which might get us to within the 17% below 2005 level goal that President Obama set in his first term, but it's not going to get us to the 26 to 28% goal by 2025, which is the goal that Obama set in his second term connected to the Paris Agreement. So there's really a big open question as to how this is going to play out, but my big take-home point is that this whiplash back and forth from different policy preferences, you can see here has some really significant impacts on what our emissions profile might actually look like. In terms of what to watch in the future, there's going to be more federal action. There's going to be further implementation of the Trump executive order. That's going to translate to more rulemakings under the Clean Air Act. There's lots of speculation about what might happen with the endangerment finding. There's sort of, recall again, that was the predicate to regulating greenhouse gases from mobile sources, and then it's also served as the basis for the other source category regulations as well. Whether or not the Trump administration tries to roll that back is a huge question. And of course, everything it does will be challenged. It'll go to court. We'll have more litigation like the methane case, and it'll be interesting to see where that goes as well. In response to the federal action, there's been a lot of state and local action. There's a group called the U.S. Climate Alliance in response to the Paris withdrawal announced that they would be working on their own to meet that 26 to 28% reduction goal. Similar commitments from local mayors. More than, I think 355 cities have also made similar commitments to act without federal assistance or without federal requirements to reduce greenhouse gas emissions. And then in addition to those two big factors, all of the market-driven effects that I mentioned earlier remain in play. So will natural gas will remain cheap and continue to be competitive with coal? Will the cost of renewables generation like solar and wind continue to plummet and help us to reduce emissions that way? Those are the areas to watch moving forward from a policy perspective. So with that, I'm done, and hopefully we can take some questions.
Erin had a bit of a work emergency, but she's happy to take any questions. I think her email is probably on the bio, and I can also try to answer her questions if you have something related to her presentation.
Yeah, feel free to forward any questions for Erin to me, and I'll get them over to them. Now's your chance on the web to get a question in so we can get to those. Anyone in the room have anything?
I have two questions for you, I think more so, Phil. On the endangerment finding, what would be the process for the administration to potentially roll that back?
So the general rule is agencies can change their minds, but in order to do so, they've got to follow an equivalent process. So the agency used a notice and comment rulemaking to issue the endangerment finding. So they did their own internal analysis. They issued a proposed rule. That rule was open for a certain amount of time to receive public comments, and then they had to give consideration to those public comments, and as appropriate and subject to their judgment, then issue a final rule to reflect that. So a process to revise it would look similar. There would need to be some sort of notice and comment rulemaking where the agency issues a proposed rule, takes comment, and then issues a final rule. But it will be challenging because there's a lot of very, very strong science undergirding the endangerment finding, and I think the agency will be hard-pressed to find and build a record.
Right. Well, that's sort of, I guess, to that point,
Yeah.
Would they not have to also sort of modify the basis, for which they can, the technological considerations that they have to think about when they're doing the endangerment finding in the first place?
So there aren't technological considerations. So it's really like the NAAQS program. It's simply a question of whether or not these air pollutants harm human health, and public health and welfare, and the environment.
And my second question, in light of the administration's decision on Paris, do you see any path forward for the Kigali Amendment?
So the Trump administration hasn't said anything about the Kigali Amendment. So for those of you that aren't familiar with it, I didn't talk about this as much, but the Kigali Amendment amends the Montreal Protocol, which is an international framework to regulate HFCs. Those are greenhouse gases with potencies thousands of times higher than CO2, but emitted in smaller quantities. So the Kigali Amendment was finalized, or it was developed, I think, in 2016. And it's, from a global perspective, it's hugely significant and consequential. But it also turns out that not everyone, but a lot of manufacturers and industry actually like it because it creates uncertainty. Whether or not the Trump administration takes a hard look at that is an open question, but thus far it hasn't come up, and it's not in the executive order.
Just want to add a bit of, I don't know if it's news, but it's breaking. Trump is meeting with Emmanuel Macron right now, and he said something could happen with Paris. We'll see. I don't know what that means, but everyone can go check their news sources after this. We do have a question from the web. Question from Catherine is, what exactly is the process for revisiting the mobile sources by the April 1, 2018, and does it include public comment?
So I don't know because the Trump administration hasn't told us how they're going to do it. It's a little bit unusual in that the regulations themselves spell out a process, and the Obama administration was as careful as it could be to follow that process when they made their determination. They were also rushed, and that's essentially the argument. So the argument to revisit the review is that the Obama administration took things too fast. They'd actually given assurances in the preceding years that the determination would be made closer to the 2018 deadline, and so we need to go back and take another look. And so I expect that whatever the Trump administration does will have to look a lot like what the Obama administration does. So a lot of technical analysis, which then translates to a number of technical documents that are released to our review and public comment. But as I said before, we haven't yet seen anything on what that timeline looks like.
Time for one more.
I have a question. Let's sort of like get your impression about something. Yesterday, a bunch of community groups, including the one I work for, through Earth Justice, filed against EPA's decision to stay their decision on ozone implementation. And just based on what you were saying, I was wondering what you thought about that, since it affects the pollution controls offered under the Clean Air Act. This stay does.
Yeah, well, I'm going to have to punt a little because I don't do as much work with the NACS program. So I'm not going to totally punt, but
I can't answer it. I'm not familiar with that.
But I will say, certainly from bigger picture from NACA's membership. So in terms of the issues that are significant to the state and local area agencies that I work with, I think that NACS regulatory issue is actually far more consequential over the next few years than for the work that they do than any of the climate stuff that I've talked about. Because I think Aaron talked about the prevalence of non-attainment areas across the U.S. There's actually been extraordinary progress over the last decades to improve air quality across the country. That's not universally true. There's still problems in a lot of areas. But with the new NACS, the ozone NACS in place, we know that is going to create a number of new non-attainment areas. And so the legal fight over whether or not EPA moves forward with that rule is very consequential, practically and from a public policy perspective.
All right. If everyone would please join me in thanking our panelists for that presentation. I'm always amazed at how much Clean Air Act information can be conveyed in 2 hours. I know that there's a lot more to it. Thank you all for joining us today, and again, thank you so much to our panelists for being here. Don't forget to join in next week and the week after for the last 2 summer school sessions. Have a great afternoon.